Knowledge drives innovation, innovation drives productivity, and productivity drives economic growth. So, good afternoon, everyone, and I am Srushti Thated, a council member of MHRD Innovation Cell at SIOP Narhe. Welcome you all to the webinar. This wonderful session has been organized by MHRD Innovation Cell of SIOP, and it's a great opportunity for all of us to learn about emerging aspects of intellectual property rights. So, to give insights on such an interesting topic, we have with us Professor Hrudaya Shende ma'am. She is currently working as assistant professor at SIOP Narhe. She has completed her M.Pharm in Pharmacology department and now she is pursuing LLB. She has recently published research papers in Walter Kluwer's Journal of Behavioral Pharmacology. She has participated in two international conferences and seven national conferences. She is a keen observer, sincere, hardworking, and dedicated teacher who always makes sure that students acquire complete knowledge about the subject. And all of us are so fortunate that today we got an opportunity to learn from her. So now I would like to invite Hrudaya Shinde ma'am to start the session. Over to you, ma'am.
As we all know, in today's dynamic and competitive world, in business environment, intellectual property is a key element needed to maintain a competitive edge in a market. extremely sorry for the inconvenience. There is some network issue. So, intellectual property. I was telling about intellectual property. Intellectual property, it means it is related to intellect of human being. That is, means person's ability to think and understand. In our day-to-day life, we come across various forms of IP. For example, we know about movable property as well as immovable property. We know movable property like car, pen, furniture, dress, but and immovable property like land, building. But intellectual properties are those like literary works, inventions, designs, any scientific ideas. All comes under intellectual property. We are surrounded by intellectual properties. For example, movies, songs, electronic devices, etc. So, nature of intellect. If we'll talk about the nature of the intellectual property, it is a creation of human mind. The properties are intangible in nature, and exclusive rights are given by statute, attended with the limitations and exceptions, and these are time bound in nature and also exist territorial jurisdiction. There is a territorial jurisdiction exists in that. It means it usually gives I, I, I would like to explain that it gives the exclusive right over the use of this creation for the limited period of time and stop and it also stop others from making, using and selling the invention without a permission of inventor. Okay, so it will define intellectual property. It is a property shall include the right relating to literary work, artistic, scientific work, performance of performance artists, phonograms, broadcast, invention in all fields of human endeavor, scientific discoveries, industrial design, trademarks, services, service marks, commercial names, etc. So this is the biggest platform for intellectual property, that is World Intellectual Property Organization. WIPO explains intellectual property as a creation of mind, invention, literary work, artistic work, symbols, names, images, designs used in commerce. WIPO divided intellectual properties in two broad categories, that are industrial properties, which consist of which include inventions and which are protected by patents, trademarks, industrial designs, geographical indications, etc. And another one is copyrights, which includes literary work and artistic works, examples, novels, poems, plays, films, musical works, etc. So the question arises why it is important to protect an innovation. As we all know that it is a creation of mind, but IPR provides a right to creator and inventor for excluding others from copying their creative work or invention without their permission. That's why we need to protect innovation. Apart from this, it also helps to market the product and monetize the efficiencies and creations spatially. After this, we need to register the protection, and after this we get ownership or possession of for that particular innovation. Okay, so if we talk about the constitutional aspect of intellectual property, the US Constitution, the US Congress has highlighted about the intellectual property or protection of intellectual property in its constitution. It says that Congress shall have power to promote the progress of science and useful arts by securing for limited times to inventors the exclusive right to their discoveries. Apart from this, Indian Constitution has no mention of IP, but just a word like property, which comes under Article 19, which talks about the freedom to acquire, hold, and dispose of for property. Article 31 talks about the protection from deprivation of property. Article 32, property could be possessed or acquired for public purpose only by law and only on the payment of compensation. But apart from this, in India, we have certain laws to protect intellectual properties, like Copyright Act 1957, which comes in the Ministry of Higher Education, Patent Act 1970, which comes in the Industrial Policy and Promotion, Design Act, Trademark Act, Geographical Indication of Goods Act, Semiconductor Integrated Circuit Layout Design Act, and Protection of Plant Varieties and Farmer Rights Act. So these are some laws in India we are having in order to protect our intellectual property. So there are some different standards of IPR. So they are categorized into certain types like patents, copyright. We might have heard all these terms n number of times in our daily life. Patent, copyright, trademark, design, database, trade secrets, geographical indication. And these in this family tree, you can see that all these intellectual properties are connected with one another. They have very narrow differences. So I will let you know how these are how these intellectual properties are being protected. So if we'll talk about the property and right over that property, if there is an idea which gives a certain kind of expression, then it can be protected by copyright. Suppose an idea which gives a certain kind of invention or innovation, it can be protected by patent. If there is an idea, if it works on quality and identity, then it can be protected by trademark. Whereas if idea works on appearance, then it can be protected by design. If idea needs to keep confidential in order to get a monetary benefits or in order to uh, for a business purpose, then it can be protected by trade secrets. So these are the certain aspects, or we can say certain standards which are protected by different means. Okay. So starting with the first, so that is a patent. Patent, in a layman's term, if we talk about the patent, it is a government authority or license for a set period of time. In simple words, we can say that it is a government authority or license for a set period of time. It is a legal body granted for a limited time by the state for a jurisdiction. It means in a particular area. Okay, limited area. Apart from this, patent system ensures that information of new invention is made available for eventual public use so as to encourage the technical and economic development. The patent, as the patent have a property rights, can be given away, inherited, sold, brought, licensed, or bonded, but also it can be revoked by the state, by the opponent in the suit, and it can be defended against infringement. There are some core features of patent system, and those features are monopoly. So it monopolizes the technology via legal means. So second one is it discloses the technology in a written form. It protects the technological advancements and promotes the innovation. So if we talk about the role of a patent system, as I told you earlier, it helps to protect the invention and creation, encourage innovation, promote the popularization and application of invention, accelerate the publicity of invention to whole society. So there are few requirements which you need to meet for uh, for getting a patent on a particular thing. And these important requirements are: it should be novel, it should have inventive steps, it should have industrial applicability. These are the three important features or important requirements of the patent. So, so novelty. Invention shall not be considered prior art means already know. It is something which already publicly known. It is already known to the people. So invention shall not be considered if considered new if it is a form. It forms a part of prior art. Second is it should have inventive steps. Like if having regard to prior art, it is not obvious uh, to a person skilled in a art at the time of filing date or priority date of application claiming the invention. Third thing is that it should have industrial applicability. It should be applicable in any type of industry so that it can be used for the betterment of society. So, what the patent document consists of? So, it consists of bibliographic information and technical information. So, bibliographic information, it should have date of filing, publications, name and address of applicants, title, classification, abstract, drawing, formulas, corresponding priority application, patent. And technical information consists of state of art, that is the state of art description about the procedure, about the methodology, how it is made, which types of elements have been added, which types of substance have been added, every detailed thing from which that particular thing is made, which is going to patent, is described in this description. Third one is drawing. Drawing consists of third one is drawing. Drawing also consists of every detail. And fourth one is claims. So these are some patent documents. Like it consists of request for the grant of patent, that is application form or patent application form. Second one is specifications, patent specification. Third one is claims. What we are going to claim, which new things, which novel things are there in our things which we are going to patent. Okay. Fourth one is abstract, and fifth one is drawing. Patent specifications and claims. Specification is the name suggests. It specifies everything. It gives a detailed and written description of about the invention. It satisfies the written requirement of patentability. Satisfy the written requirement of patentability means it should be novel. It should have inventive steps. Third one is it should be used for industrial application. It also defines the scope of particular claims which we are going to. Okay, so patent specification have a background of invention, summary of invention, description, detailed description of drawings, detailed description of invention, and sequence listing. This is how the abstract look like. Abstract is nothing but it is a short summary of invention written in one paragraph that goes at the beginning of it. Application of patent. So it gives a brief idea about the patent. Second one is drawing. This how the patent drawing look. This is a sample of patent. So in this, the title, you can see the title, inventors, who has invented these patents. Apart from this, assignee is also there. Prior art references are also there if there are any prior arts. Okay, specifications, every detail about every detailed description about a patent is specified in this column, and claims. So now coming toward the comparative study of Indian, American, and European patent laws. So Indian, American, and European patent laws like one have little or more differences, like first to invent or first to file. For example, in US patent, like in American patent system, what happens in American patent system, two or if two or more applications are filed if two or more applications are filed for a similar invention, the determination will be made as who has invented it first. So first to invention. So in United Nations, the patent will be given the who has invented that particular invention first. In case of Indian scenario or in European scenario, when two or more people apply for a same patent on a similar invention, the person who files the application of the patent at first considered by the office of patent first. Okay, so this is the vast difference between American and European patent system. So our Indian patent system follows almost like European patent laws. If we'll talk about the grace period, in European and Indian scenario, the application of the patent will be rejected if the invention of a person had become available publicly in any way before the application of patent was filed in the patent office. But in United States, the scenario is different. In this, what happens? 1 year grace period is given. 1 year grace period means the inventor of the invention has authority to publish the invention for a period of 1 year before the filing of application of patent. So this is the second difference which we can see in the European and American patent system. Whereas third one is a requirement for the novelty, utility, and non-obviousness or inventive steps. Um, these features are very common for United Nation, United European Union, and Indian patent system. So these are common features. Best mode. Fourth one is, if we talk about the best mode of patent system under the United Nation patent system. Complete specification of the patent should contain a written description of the invention, the manner and the process of using, making the invention in such clear and concise and full exact terms so as to enable any person skilled in similar art. But in India, the scenario is different. The applicant of application of patent is required to disclose the best technique of carrying out the invention. So in Indian scenario, the best technique should be highlighted. Okay. So fourth point is publication of patent applications. In US, application of patent are published after 18 months from the date of filing of application of patent in the Office of Patent, unless the cases where the applications of patent is withdrawn or filed with a request of non-publication. In United States, the scenario is different. We have to file non-application request. But in Indian and European patent system scenario, the applications of the patent are published after the 18 month from the date of filing, unless the application of the patent is withdrawn by the applicant. So the difference is like, the primary difference is like, there is a request for non publication, which cannot be made in Indian scenario, in Indian patent system. Okay. So fifth point is right conferred by granted patent. The patent for India or US is a property right that is enforceable in whole territory of the both countries. In United States, what happens? It holds a unique feature in this context. United Patent Office or EPO only grants United Patent European patents for member states of European Patent Convention. An application of an applicant of application of patent file a single application for European patent and designate the different countries in Europe in which the applicant wants to have protection of patent. Opposition after grant of patent. So in the Indian the patent law in India only deals with the patent opposition, whereas in US a procedure of re-examination of patent is there. So here, in India we can one can file a patent opposition, but in United States the procedure for re-examination of patent is there. Language of the patent. Last one is language of patent application. There are certain differences in filing the application for the patent in United States, European Union, and Indian patent law. The patent offices of US and India only deals with the English language. However, in European Union, uh, in European patent office have English, French, German as their official languages. So the conclusion is that after thoroughly analyzing all these points, United States, European Union, and Indian patent law, uh, it can be held that the procedure for granting of patent in India is quite similar to European Union and completely different from United States. So our Indian patent system almost follow the European patent system, which is a little bit have a stricter approach. So, if we'll talk about the patenting of medical inventions in USA, the patent law generally takes a fairly liberal approach for patenting of medical inventions, whereas European patent office takes much stricter approach. For example, invention only has to meet a standard test for patentability in USA, like utility, novelty, and non-obviousness, and it is similar to European patent system as well. But also the patent law explicitly exclude from patentability like method of treatment of human or animal body by surgery or therapy and diagnostic method practiced on the human or animal body. These methods are explicitly excluded from patentability. So we could not file a patent on the method of treatment of human or animal body by surgery or therapy. For the sort of example, can we can say that a method of surgery for correcting vision using non-surgical tool, it is patentable in US. The sample claims that a method for correcting vision, a method comprising of steps, residing patent laws as per European patent laws. The case laws of EPO has established that any surgical method, regardless of its purpose, any surgical method is excluded from patentability. Regardless of its purpose, any surgical method is excluded from patentability. This means that any surgical method of treatment of human or animal body by surgery or therapy or diagnostic method practiced on human or animal body, these are explicitly excluded from patentability. Third example is patenting of diagnostic method in US and Europe. So method of testing blood sample to diagnose diabetes, it is patentable in US. The sample claims that method of testing blood sample, it is a method comprising of steps. But in European scenario, what happened? An in vivo method of testing blood sample to diagnose diabetes is not patentable in European scenario. It is excluded because the diagnostic method are uh, those diagnostic methods which are carried out on living beings are excluded. Apart from this, if the method of testing in vitro blood sample to diagnose diabetes is patentable if it is in vitro method. Then it is patentable because it is because what happens, it is removed from the body. It is and which is not excluded if the sample is permanently removed from the body. Excluded if the sample is returned to the body. So these are the conditions for for which this particular diagnostic method is patentable or not patentable. So third one is patenting biotechnology invention. In 1987, USPTO approved the Harvard patent for oncomouse. If these are the animals must be given a new form of quality, properties, or combinations not present in the original article existing in nature in accordance with existing law. The oncomouse clearly met the criteria. Apart from this, in United States, it gave the patent in 1987, whereas in 1990 now coming towards the patent infringement cases. Patent infringement cases, the best example is Apple versus Samsung. So Apple has sued Samsung for copying its product idea. Like it has filed a 38-page suit in the US District Court, and its look, product design, and packaging. This is how the patent of Apple and patent of Samsung look like. So what happened? Apple also highlighted few points like Apple invented a pinch to zoom technology in 2007. Apple launched the iPhone with a new pinch to zoom technology, and Samsung launched the Galaxy phone with same pinch to zoom features later on. So Samsung again filed a patent. Samsung filed a patent in 2012 for pinch to zoom feature. So in this scenario, what happens? Apple has first invented. We have seen in earlier slides that the one who has invented first given a patent in United States, and the one who has applied, the one who has given application for a patent is given patent in European patent system. So in this scenario, what happens? The first inventor is Apple. Apple has a right to patent. So according to United States patent system, the Apple has a right to patent. Apple filed a sued. Apple then sued Samsung for this infringement. Then first inventor to file. Apple's use of pitch to zoom technology feature qualifies as a prior art and bars Samsung from obtaining the patent. This is a prior art. Prior art means something which already known to people, which is already publicly known. Apple has a right to patent. So Samsung has taken turn like it is the world's largest manufacturer of maker of smartphones, countersued the Apple. It has countersued the application technology and camera phones. But later on, the verdict came, and the jury has found that Samsung was guilty of infringing the Apple's design of patent. And the verdict came in favor of Apple, and rejected all the Samsung's claim, and leading device may be banned in US. So this was one of the interesting case study of patent we can see. Second case study is that can patentee claim a patent on cloned animal. Like we already know Dolly ship. This question actually was posed by Keith Campbell and in Walmart, a creator of Dolly the ship, a mammal clone from an adult somatic cell at the Roslin Institute of Edinburgh. So this is a process by which cloning cloning of ship is done. So the process is called as process is called as somatic cell nuclear transfer. So first of all, what happened? Roslin Institute of Edinburgh has filed an application to claim a patent on Dolly the ship. The claim says that any cloned animal, especially sheep, goat, pigs, but it was initially what happens rejected by USPTO, that is United Patent System, and examiners by saying that one could not patent a natural phenomena because they were patenting sheep, goat, and pigs. Okay, the Roslin Institute again filed an appeal with the Patent Trial and Appeal Board. After few years, like after prolonged 18 years of patent battles, on 8th May 2014, the Patent Trial Appeal Board in Washington agreed to the decision of Patent Trial Patent Trial Board. The cloning method can be patented the product associated with it cannot be claimed for the patent. So they got animal, Dolly the ship, that is an animal. They didn't got a patent for animals, but they got a patent for method of cloning. So one could not patent the national towards the next intellectual property, that is a copyright. We have listened this term ample of times. So copyright, it is a kind of work, it is a familiar term to most of us, even without any knowledge of IP. It is a right which is given for protecting of a literary and artistic work of a person such as music, novel, movies, arts, etc. So these types of works comes under copyright. It also includes films, choreography, artistic works like paintings, drawings, photographs, sculpture, architecture, advertisements, maps, and technical writings. So, which types of rights which are covered under copyright? There are two types of rights which covered under copyright, that are moral rights, moral rights, and economic rights. So, moral rights protects personality of author, whereas economic rights brings the economic right of authorship, right of integrity, which consists of digital manipulation, no right for display, inalienable rights, whereas economic rights consist of different types of rights like right of reproduction. It means making a copies. Right of reproduction. It allows making a copies, example, and edition of novels. It also allows the storage in computer memory, whereas right of distribution or issuing copies, uh, it allows a digital distribution in the public domain. Okay. Right of communication to the public. It allows the public performance and internet communication. Second one is right right to make a cinematograph, film, or sound recording, translation rights, adaptation rights, which covers the conversion into one into another form. For example, literary to drama. If there is a kind of literature and which can be converted into dramatic form and presented, so these rights are also available. Second is the picturization, comic formats comes under this adaptation rights. Now, after that, translation rights are there. Rental rights are there. Resale rights for original artistic works are also included in economic rights of copyright. Other related rights are literary rights, which is for author, drama, for dramatist, music for composer, artistic work for artists, painters, sculptor, architect, etc. Photographer, author of computer program, the first person who caused a work to be created. Cinematograph for a producer and sound recording also there for ownership of rights. Now duration of the copyright. So the work published during the lifetime of author, life plus 60 years, are the copyright duration. It can be given posthumously. It can also be given for anonymous work. It can be given for the work of government and organizations. It can be given for cinema, sound recording, photographs, etc. And other related rights are there, that is performers rights and rights of broadcasting, recording, broadcasting and communicating to the public for a live performance. It comes under performance right and presumption of transfer of performance right to cinematographic film producer is also comes under this right, and its duration is for 50 years. Whereas broadcasting of reproduction right, broadcasting, recording, and communicating to the public of broadcast comes under rights of broadcasting organization. Third intellectual property we are talking about is that is trademark. Trademark is it is a right protecting a goods and services of a company or a person. In simple terms, if we talk about third one is trademark. So trademark is a right pertaining, right protecting goods and services of a company or a person. So we can say it is a name of enterprise or mark capable of being represented geographically, distinguishing the goods or services, as I told you, of a person for those of others. For example, like Lux, Bodwig, TVS, Telco. These are the trademarks. So trademark can be a sign, a word, letter, brand, logo, slogan, drawing, color or combination of colors, shape of goods, graphic representation or packaging, or any combination of above the things listed over here, as applied to the article or a product. So registration for a trademark, it can be registered by national trademark registries and valid in that particular country. Registration is made after the examination and publication. The period of registration is for 10 years, and it can be renewed indefinitely. There are certain kinds of trademarks, like marks on good, service marks, certification trademark, collective marks, well-known marks, and trade names. For example, service marks highlights banking, education, finance, insurance, real estate, entertainment, affairs, transport, conveying news, information, advertising, etc. Whereas certification trademarks are certified by proprietor which have certain characteristics like geographical, geographical origin and ingredient and quality. For example, egg mark is there, wool mark certification. Uh, but the certification mark cannot be used as a trademark. Okay. Second is collective mark. The name indicates collective mark is the mark that distinguishes the goods or services for the member of association from mark of other undertaking. It could be a manufacturer, producer, supplier, trader, or other professional bodies like Institute of Chartered Accountant, Test Cricketer Associations, etc. So it is used for a collective term. It is not used for a single person. It is used for the association of persons. Well-known marks, for example, Coca-Cola, trade names, Godrej. So there are various forms of trademarks. For example, visual form, which consists of word, letter, numerals, devices, which includes the drawings, symbols, 2D or 3D, 2D or 3D representations, color combinations, etc. And in audio category, that is sounds or musical notes, and olfactory, which includes the smell, like it also includes perfumes, etc. So these are some trademarks you can see. So one question arises: what is not protected under trademark? So state emblems, official hallmarks, emblems of intergovernmental organizations cannot be used as a trademark. Cannot be used as a trademark. Another intellectual property we're talking about is geographical indication. Geographical indication, we know very well, it is an indication that originates from indefinite geographical territory. It is used to identify agricultural, natural or manufactured goods. It should have special quality and reputation or other characteristic of community rights. Another important feature of GI is that it possess certain features from a location because of its origin from that particular location. For example, basmati rice, Darjeeling tea, Kanchipuram silk, Alfonso mango, Nagpur oranges, Kolhapuri chappal, Bikaneri bhujia, Agra petha. All these are geographical indications because in this the feature of the important feature of location is added here because it is the origin. And in Indian scenario, there is one initiative for GI geographical indication tags run by government of India for geographical indication. So now how to register geographical indication. In India, what happens? Geographical indication registry is done and it is examined and publish the application before the registration. So before registration, uh, GI geographical indication is examined and publish the applications. So registration for GI is valid for 10 years, but it can be renewed indefinitely. So the rights which can be granted over GI, that is exclusive right to use GI on goods, right to obtain relief for infringement of geographical indications. Another 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 intellectual property is trade secret. Some inventions, data, information which cannot be protected by by any of the available means of intellectual property rights. Such information held confidential as a trade secret. It means it can be a formula, it can be a process, or it can be a business information that is kept confidential to maintain an advantage over the competitors. Okay, so trade secrets can be, I told you, invention idea, survey method, manufacturing process, experiment result, chemical formula, recipe, financial strategy, client database. These all comes under trade secrets. Sorry, trade secrets. Another example is also there, that is the method of, for example, method of making Coca-Cola. So these are examples like secrets of secret components or formula, manufacturing or processing method, business plan, research and development information, customer supplier list, marketing plans, IT system architecture, unpublished promotional material, information regarding business opportunities, sales price, cost data, confidential software application features, etc. When the trade secrets are preferred, when the invention is not patentable, trade secrets are preferred when the invention is not patentable, when patent protection is limited to 20 years, when secret can be kept beyond that period, okay, when the cost of the patent protections are prohibitive, and when it is difficult to reverse engineer. So in this condition, the secrets are preferred. Now, how to guard trade secrets? So we can restrict the number of people having access to secret information. We can also sign a confidentiality agreement with the business partners, and we can also use the protective techniques like digital data and security tools. And legislation provided protection in the form of injunction and damages if the secret information is legally acquired or used. So, all these we have talked about the intellectual property. Now, coming to the organizational structure of intellectual property offices in Indian scenario. So, it first of all it comes under the Ministry of Industry and Commerce. The Office of Controller General of Patent, Design and Trademarks works under the Ministry of Industry and Commerce, and it has uh, offices at different locations. For example, the design wing is located at Kolkata. Patent offices are located at the four locations: Mumbai, Delhi, Chennai, and Kolkata. Trademark registry offices located at Kolkata, Delhi, Mumbai, Ahmedabad, Chennai. GI office registry is situated at Chennai, and Patent Information Service office is situated at Nagpur. So this is organizational structure of IP offices in India. Now talking about the WIPO, that is World Intellectual Property Organization. So it is one of the 15 specialized agencies of United Nations, and was created to promote and protect intellectual property across the world by cooperating with different countries as well as international organizations, and its headquarters is located at Geneva, Switzerland. WIPO currently has 193 member states, and the activities like hosting forums, providing global services that register and protect intellectual property, resolving transboundary intellectual property disputes, helping to connect intellectual property system through uniform standards and infrastructure, and services as a general reference database on all IP matters are the activities which included or which carried out under World Intellectual Property Organization. Now, there are n number of conventions which talks about intellectual property. The important of those are Paris Convention and Berne Convention. Paris Convention for the protection of intellectual property and Berne Convention for the protection of literary and artistic work. And both are administered by WIPO. Intellectual property rights also mentioned in Article 27 of Universal Declaration of Human Rights. And the World Trade Organization also governs intellectual property through trade-related aspects of intellectual property rights, that is TRIPS. So, if we'll talk about India and intellectual property scenario, in Indian scenario, various objectives are there. Various objectives like intellectual property awareness, outreach and promotion, generation of IPRs, legal and legislative frameworks are also designed by like we have seen the different laws for intellectual properties. Administration and management is also there in order to modernize and strengthen the services oriented to IPR administration, whereas another objective is the commercialization of IPR, so that we can get a value of IPR through commercialization, enforcement and adjudication in order to strengthen the enforcement and adjudicatory mechanism for combating and IPR infringements. Various infringement cases are there. One of those we have seen, like Apple versus Samsung in today's case study. Okay, so in order to combat all those infringement cases, we should have a solid adjudicatory mechanism. So this is also one of the objective of IPR in India. And last one is in human capital development. It helps to strengthen and expand the human resources, institutions, and capacities for teaching, training, and research and skill building in IPR. So these are some references. So here I conclude today's session. Thank you for patient listening.
Thank you, ma'am, for an absolutely amazing session. I'm sure that all of us have acquired valuable knowledge through this session, which will definitely help us all in future. Now, it's a great opportunity for audience to learn some more by asking questions to ma'am. So, if any questions are there, please ask.